Good morning. My name is Aisha Yakub, and I am the Policy Director at Asian Americans Advancing Justice Atlanta. Today, I stand here with legislators, community advocacy groups, and immigrant rights organizations to oppose Senate Bill 452. From the bill's inception, we have been adamantly opposed to the bill and all of its measures. It is no secret that this bill is yet another attempt to show our immigrant families that we are not welcome here, that we are not safe here, and that the state of Georgia is not welcoming them. In its current form, SB 452 contains a host of constitutional and administrative issues that will only make things harder for our people, our government offices, and law enforcement. Particularly, allowing judges and prosecutors to inquire and discern immigration status will only add an additional burden to the already clogged court systems. The Council of Municipal Judges, as testified in the House committee hearing, has already spoken out against this bill. I'd like to pass the mic along to our state representatives who have been adamantly opposed to this bill from the beginning, and to our fellow community organizations who have supported our efforts.
Good morning. My name is Bee Wynn, and I represent District 89, which is City of Atlanta and DeKalb County. Today, I stand in opposition of Senate Bill 452. It places undue burden on our state and judicial courts. It strips municipalities and local jurisdictions of their authority and prevents them from being able to govern their own local communities. Last week, I listened to over 2 hours of public testimony in committee. Municipal court judges, state court judges, nonprofit leaders, and faith-based organizations share compelling testimony against this legislation. Senate Bill 452 requires officers of the judiciary to carry out the functions of our executive immigration enforcement agency. Under Section 4 of the bill, members of our state court must decide whether the defendant is lawfully present in the United States under federal law. In other words, if a person is being tried for a crime, the judge must also decide if the defendant is lawfully present. According to testimony provided by 3 municipal judges and 2 state court judges, making this determination is not within the scope of their professional obligation or ability. It would require overburdened court systems to provide training and education pertaining to complex and ever-changing immigration law. A municipal court judge estimated that adequate training for the 7 people in his courtroom would cost nearly $500,000. Senate Bill 452 provides no fiscal notes or appropriations. Let's call it exactly what it is. It is an unfunded mandate. Further, forcing our local jurisdictions to cooperate with ICE is a dangerous proposition. We all want to get rid of the bad guys and make our communities safer. But we should never forget we must also always do this under the law of our land. ICE has proven to be an unscrupulous federal agency with a troubling history of unconstitutional and clandestine rights violations. ICE has no connection to our local communities and no stake in community safety. Surrendering our state and local power to an unchecked federal agency is a dangerous proposition. It means detaining and deporting those without felony criminal convictions. It means raiding communities without warrants and without obtaining lawful and voluntary consent. It means denying detainees the right to counsel. It means indefinitely holding mothers and children in for-profit detention centers. I know this to be true because I have witnessed it in the communities that I work with. Women left without their husbands, daughters left without their fathers, and families left without their breadwinners. These deportations happen quickly and cruelly, and with little or no transparency. These actions do not make our communities safer. They instead put us at risk for costly lawsuits and dilute our state authority. We must be very careful when surrendering state and local control, because once we make that decision, it will be too hard to go back.
Good morning. I am Representative Deborah Gonzales, representing House District 117, and I am here to support these community agencies and also to support my fellow representatives in opposing Senate Bill 542. What I would like to bring to your attention is the importance of language and words. What we say does, in fact, affect what happens in our communities. A shall or a may can make all the difference in terms of whether we are welcoming to those who actually contribute so much to our communities or whether we are shunning them away. in a state where we pride ourselves in being number one in business, in a state where we pride ourselves in being number one in industries such as agriculture and movie production. We must remember that we also need to be number one in terms of our humane treatment of those that we welcome into our community and our state. That shall and that may, that language that is threatened right now to take away local control through Senate Bill 452 is something that we must stand against. For once it goes through on this bill, it can also go through on other issues. We ask you to stand with us, to speak to those who represent you so that they know about your opposition to Senate Bill 452. Thank you.
Good morning. Pedro Marin, District 96, representing Norcross and Duluth in Gwinnett County. And I'm here today with my colleagues and several community leaders and asking the question, have we learned something in this state from HB 87 back in 2011 when we saw the devastation that HB 87 did to our state, especially in industry such as agricultural. There was towns that were ghost towns, business that closed, churches that didn't have any parishioners in them, and that was what happened with HB 87. Again, I think it's hard for us to play political game amongst our elected officials trying to get elected on the primary, again, undermine the immigrant community and the things that our immigrant community brings to this state, because I would need to get elected. So again, let's remember back 2011 of what happened to HB 87 and to the devastation that did to this state, and that can actually happen again with SB 452. Thank you.
Good morning. My name is Eli Echols. I'm an immigration attorney. And I'm here on behalf of the American Immigration Lawyers Association, the Georgia-Alabama chapter. And I just want to support all the comments that are being said today, but I'll just focus on try and give a really practical perspective on what it means for some of these adjudicators in the state, all the way from a municipal judge all the way up, to actually try and do what the statute says, which is inquire and determine whether a defendant is lawfully present in the United States under federal law. I think it's been said already in prior testimony, but lawfully present is not a federally defined term under the law. And the kinds of folks that might end up in front of one of the judges in our state are folks like victims of crimes or victims of domestic violence, both of whom, both the kinds of folks in those positions might have no legal status whatsoever as far as immigration goes, but under immigration policies and under immigration procedures and laws, they'd be allowed to stay here while they wait for an application that's pending, either for a U visa or an application under the Violence Against Women Act. What would a judge do with a person like that who cannot claim a status but who otherwise is permitted to be here by federal authorities? We're all familiar with the green card, the idea of lawful permanent resident status. That's a status that only an immigration judge or someone reviewing that decision can take away. But you can become eligible to lose that status through the commission of a crime. So what's a judge to do if a municipal judge knows a person who can demonstrate lawful permanent resident status but has committed a horrible crime, but no judge has taken that status away yet? So is the judge to say that they are in a lawful status and therefore it doesn't trigger what the law requires? Or do they assume some sort of conclusion in immigration court that the person will lose that status and therefore trigger what the law is supposed to do? An example of this in real life is a man named Adrian Moncrief, who a number of years ago here in the state of Georgia was pulled over and cited for possession of marijuana with intent to distribute. He was a lawful permanent resident and he was ordered removed. A few years after that, the Supreme Court ruled that, in fact, he had not lost his status and that he would be permitted to retain his lawful permanent resident status. That's the kind of analysis and complex issue spotting, and that we're asking even judges down at the municipal court level to conduct with this bill. Some people are citizens and don't know it. Might be able to prove it after having a run-in with a lawful presence analysis in front of a state court judge. Others think they're citizens, and it turns out they're not, and they could credibly say, I believe I'm a citizen, and get through, and yet maybe turn out not to be citizens. So there's just no. We have an entire immigration court system that struggles every day with a huge backlog with these kind of complex questions. They shouldn't be, and they cannot be reduced to a simple inquiry of lawful presence that's not defined in federal law to be conducted in state courts that don't have the legal research libraries or skills to conduct this analysis. And so in addition to all the other numerous problems created by this bill that everyone else is citing, we would just like to make sure that everyone understands the tremendous burden and confusion that this bill will create in our courts. Thank you.
Good morning. My name is Marissa Dodson. I'm the Public Policy Director at the Southern Center for Human Rights. I stand in solidarity with these individuals and organizations today to oppose Senate Bill 452. I'm specifically here to talk about the secretly added language in sections 2 and 3 in the bill now that relate to bail reform. The last several years of criminal justice reform in Georgia have been deliberate and intentional on thinking about effective strategies for reforms that will improve folks' lives and save taxpayer dollars. Not only does the majority of Senate Bill 452 run counter to criminal justice reforms in this state over the last several years, but the bail provisions of this statute or this bill go even further. What the concerns that we have is that right now, all over the country, there's a challenge on wealth-based detention that is incarcerating folks simply because they are unable to pay money for their release. Local jurisdictions like the city of Atlanta have taken strides to end wealth-based detention such that people can be immediately released when they are charged with things like holding up a sign and saying that they are homeless or walking while being intoxicated. These are low-level offenses that charge local governments high costs, not only in financial costs, but also in human costs. So this bill, or these provisions of this bill, go at or seek to control or limit local options to think about their resources in a different way. Not only are we concerned about the constitutional considerations around wealth-based detention that this bill would require. Right now, the language says that if you are, that no one can be released on their own recognizance unless they have seen a judge. The problem with this is that people in Georgia are waiting days, weeks, and sometimes months before they are able to see a judge. So this would mean that we would be exacerbating our wealth-based detention, moving in the wrong direction as a state. Now, Georgia has been considering bail reform. There have been several bodies over the last several months that have considered what we might do in this state to deal with our pretrial justice system. The Governor's Council on Criminal Justice Reform and an ad hoc committee of judges comprised or put together by the Judicial Council of Georgia have been considering these reforms. Those recommendations are in the council's report. You can find that online. Some of the recommendations that the council and those bodies have made are in Senate Bill 407. This bill and Senate Bill 452, these bail provisions were not discussed in committee. It was a clandestine effort that was done by the bail industry that feels threatened by what Georgia is trying to do to end wealth-based detention. And so what we are asking for is for this, not only for the entire bill to be opposed, we stand in opposition to the full 452, but specifically we are concerned about sections 2 and 3 of the bill as it relates to bail. We would ask that those provisions be removed and overall that the bill be voted down. Thank you.
Good morning. My name is Jerry Gonzales. I'm Executive Director of GALEO, the Georgia Association of Latino Elected Officials. I want to take a few steps back in history. In 2006, the Georgia legislature passed SB 529. And at the time, they said, this is the bill that's going to end illegal immigration in Georgia. 5 years later, same claim was made. we are going to pass HB 87, and this bill is going to end illegal immigration in Georgia. What happened after 2011? Our agricultural industry suffered tremendously. It's estimated that more than 70% of the agricultural workforce are undocumented immigrants. What happens if 3/4 of our workforce in agriculture disappear? For every one farm worker that picks the crops, generates 7 other jobs for Georgia's economy. It is the #1 industry for our state, but clearly our elected officials in the Georgia legislature don't care about our agricultural industry. What will happen if this bill goes into effect? So my message is not to the Georgia legislature. My message is to 2 people. We need to make sure that Facebook, Jeff Zuckerberg, and as well as Amazon's Jeff Bezos understand what's happening here in Georgia. Just because they're thinking of coming to Georgia, they're coming to a place that actively pushes anti-immigrant, unwelcoming legislative initiatives year after year in order to further their political rhetoric. Not for policy substance, but to further their political rhetoric. If Georgia cares about the future of economic development, if Georgia cares about our agricultural industry, if Georgia cares about the movie industry that employs many immigrants as well, if they care about those industries that are adding hundreds of thousands of jobs to our Georgia's economy for the future, then we would see this bill quietly die this legislative session. If not, well, Amazon and Facebook, you have your answer. Georgia is an unwelcoming state if this bill moves forward, and we don't want that to happen. So I'm here to stand in solidarity with my friends to make sure that we vote no on SB 452. Thank you.
Good morning, everyone. My name is Murtaza Khwaja. I'm the staff attorney with the Council on American Islamic Relations here in Georgia. As the prominent civil rights and advocacy group for the Muslim community and American Muslim community, we're proud to stand here with our allies in the civil rights community to fight SB 452. While SB 452 might be the bill that we're here to talk about today, the rhetoric and the feelings behind it is nothing new. The anti-immigrant, the xenophobic, and the discriminatory intent that's in the bill and in the text of the bill is something that we've seen throughout this legislative session. And it's something that too many legislators in the Georgia legislature are comfortable in showing their prejudice against the immigrant community. This is not the 1950s, and we're here to say that in 2018, we're not going to allow 1950s legislation to be passed. If this bill, you've heard so far the constitutional and practical implications of the bill. But if this bill goes into effect, and which it may, the injustice that it places upon people is going to be immense. But surely whenever there's injustice, those who speak out against it and those who resist will prevail. The resistance won't just come from people here in this room and the groups that I'm flanked with. It'll come from, as we've heard, police departments, sheriffs who understand that this type of bill is going to degrade the trust in their community. It's going to come from judges who understand the constitutional implications of this bill and what unconstitutional measures it places upon them. And it's going to come from people who will want to protect their neighbors, people who want to protect their allies, people who want to protect their friends, their schoolmates, the people they work with. And, as I said before, the people up here, the groups here, the civil rights groups up here with me, will fight this, not just in court, but also at the grassroots level, where we'll make sure that legislators who introduce this type of bill and who have this type of rhetoric and who have this type of prejudice against our immigrant and minority communities, some of whom are the most vulnerable in Georgia, will make sure that those legislators don't see it to the Georgia Capitol. Thank you.
Thank you to all of our speakers today. I just wanted to take a minute to explain what we have in front of everyone today. We are delivering over 1,000 letters to Governor Nathan Deal and over 1,000 letters to Speaker David Ralston today in opposition to SB 452. Over the last 2 weeks, our community organizations, in addition to the Georgia Coalition Against Domestic Violence, the Feminist Women's Health Center, Planned Parenthood Southeast Advocates, and other groups that have supported our efforts, have been collecting letters speaking out against SB 452 from our communities here in Georgia. As we deliver these letters, we speak the words of business owners, community organizations, faith leaders and organizations, and individuals from across the state who understand the importance of uplifting immigrants and not degrading them through bills like SB 452. We invite the media to join us as we deliver these letters, but we are open to questions at this time. And if there are no questions, then we will be delivering these letters. Mhm. Okay.
Lo que necesitamos es que las personas llaman a sus representantes y a sus senadores a decir que están opuestos a este bill de Senado, el 452. Es muy importante que ellos sepan que tienen el poder de poder tener una voz y llamar a sus representantes, porque esa es la única manera que podemos decir que no queremos esto, para que sus representantes entonces votan contra esta legislación.
Sí, el impacto económico va a ser muy grave en contra, que va a ser en efecto si sale esta legislación adelante, porque lo que hemos visto en 2011, que esta legislación le costó a los agrícolas, a la economía agrícola, $100 millones, más de $100 millones. Y vamos a ver que este tipo de legislación, si se pone en efecto, va a causar bastante miedo en nuestra comunidad y posiblemente se va a ir la comunidad del estado de Georgia. No queremos eso, por eso estamos aquí peleando, pero por eso nos da bastante preocupación, porque la economía del estado de Georgia depende en la labor y esfuerzos de la comunidad latina y la comunidad inmigrante. Y por eso estamos aquí muy fuerte en contra de esto, porque no solamente también para defender los inmigrantes y los latinos aquí, pero también defender la economía del estado de Georgia. Es muy grave esta situación y por eso estamos en contra. También, si la comunidad se quiere involucrar, que nos puede seguir en Facebook, vamos a tomar bastantes llamadas de acción en Facebook, pero también si no están registrados para votar, que se registren para votar. Este es una tipo de legislación para promover la política, y si no nos involucramos y participamos en las elecciones de este año, van a continuar a hacer este desrespeto a nuestra comunidad. Nosotros como comunidad tenemos el poder de cambiar quién va a salir adelante de gobernador, quién va a salir adelante de los congresistas, y tenemos que salir para votar. Y es importante que la comunidad se registre y salga para votar en mayo y también en noviembre. Gracias. Le mandé un mensaje directamente a Facebook y a Amazon, porque los legisladores no están escuchando. No están escuchando toda la precaución que le estamos dando nosotros. Y lo que estamos haciendo es mandarle el mensaje a ellos, para que ellos tienen el poder de, en efecto, matar esta legislación antes que salga adelante. El gobernador Nathan Deal y el speaker Ralston tienen que oír de estas compañías para asegurar que esto no salga adelante, porque si sale adelante, ellos no deben de venir al estado de Georgia, porque este estado va a ser bastante en contra de los inmigrantes, y eso no son los valores de esas dos organizaciones.
¿Crees que sería un impacto negativo si se aprobara esta ley y estas compañías no vendrían a nuestro estado?
Claro que sería un impacto muy grave para el estado. Por eso estamos aquí peleando para el desarrollo económica del estado del futuro, porque es importante para todas las comunidades aquí en el estado de Georgia, y por eso estamos aquí peleando, porque si esto sale para adelante, entonces va a causar bastantes problemas, no solamente en este año, pero en varios años adelante también.
Finally, Pedro, can you explain to me a little bit about what is the current situation in this bill?
Mira, básicamente SB 452 está en el comité de reglas, que es el que mira el calendario del piso de la Cámara de propuestas que se van a presentar al frente de nosotros. Acuérdate que también en el comité se hicieron unos cambios a la SB 452. Así es que si va al piso de la Cámara y votamos que sí, entonces tendría que regresar al Senado, porque han abierto unos cambios. Ellos estarían en acuerdo o desacuerdo, y si están en desacuerdo, pues entonces iría al comité de conferencia. No obstante, cuando hablé de la HB 87 del 2011, me acuerdo bien de que esa propuesta salió de nuevo a las 11:30 de la noche, a media hora de nosotros irnos para nuestras casas, para el final de la sesión legislativa. Y ese es el miedo mío en estos momentos, de que pueda suceder lo mismo que sucedió en el 2011 con la HB 87, que salga así de repente y tengamos que hacer un voto inesperado.
¿Cuándo sería el último día o la fecha límite?
Mira, nosotros tenemos hoy, martes, y el jueves. Nosotros estamos aquí el jueves hasta un poco después de la medianoche, cuando terminamos nuestros trabajos legislativos hasta el próximo año. Y da pena de que pues tengamos usando a la SB 452 de nuevo como un juego contra cientos de miles de inmigrantes en el estado de Georgia para poder salir electos en una primaria.